Mr. Deere, can you hear me okay?
Yes.
All right. Mr. Deere, the purpose of today's court appearance is to give you information about the court process, to advise you of your constitutional rights, to advise you about the mandatory protection order, and to advise you about the charges that have been brought against you. Please listen carefully to all the information. It is important that you understand what is going on so you can make reasonable and intelligent decisions about your case. Again, can you hear me okay?
Yes.
All right. The first right which you have, Mr. Deere, is the right to remain silent, which means that you do not have to talk about the charges to anyone. You must understand anything which you say concerning this case can and may be used against you. These proceedings today are being transcribed, and anything you say today about your case can be used against you. Second, you have the right to have an attorney to represent you. This right of representation starts right now. If you do not have a lawyer and you wish to have a lawyer, the public defender will be appointed to represent you because you are in custody. If you're found to be indigent according to certain financial guidelines, the Colorado Public Defender's Office can represent you. Also, you're free to hire your own attorney if you so desire. Now, you have a public defender standing next to you. I assume the Public Defender's Office is ending their appearance at this time. Is that correct?
Yes, Your Honor. We believe we had an application filled out and signed by a duty judge over the weekend. I would ask the court to formally appoint my office at this time.
All right, I do have the application in front of me, and the defendant is in custody, so the court will appoint the Public Defender's Office. In the present case, Mr. Deere, the initial charge is murder in the first degree. That being said, there is no bond set. At a later date, we will have a hearing to determine if a bond should be set. Any pleas which you make to the charges must be voluntary and not the result of any undue influence or coercion. You have the right to a jury trial on the charges against you. As I stated earlier, the initial charge against you is murder in the first degree. The penalty for that charge is minimum of life in prison and maximum of death. You also have the right to a preliminary hearing. A preliminary hearing is a hearing before a judge in which the district attorney must prove there is probable cause to believe that you have committed the crimes charged. You should be aware also, in this case, like in all criminal cases, there is a temporary restraining order against you. You are hereby restrained from harassing, molesting, intimidating, or retaliating against any victim or witness. The restraining order will remain in effect throughout the term of your case. Your case has been assigned to Division 10. Do you have any questions about any of these rights, sir?
No questions.
Okay. Does the public defender wish any additional advisement?
No, Your Honor.
Does the district attorney know the next step is that we'll have another hearing in Division 10, and the next court date there'll be the formal charges, formal statement of charges against you. Does the district attorney know when that you'll be ready to file the charges?
Talking with your staff earlier, I think we talked about next Wednesday at 1 or 1:30, whatever the court's
Okay.
talking time is.
Does the public defenders have any objection to the filing of the charges next Wednesday at 1:30 in Division 10?
That would be a week.
We have 1 moment, Your Honor.
A week from Wednesday, I
A
guess.
week from Wednesday. Yeah, not this coming Wednesday, but a week from Wednesday.
That's fine.
So that would be the 9th, is that right? I think that's right. December 9 at 1:30? All right, December 9 at 1:30 is going to be our next court date, and that'll be in Division 10. Now, I have also received a number of other motions. Did the Public Defender's Office wish to make any statement in regard to those motions?
Judge, the only one that I wish to address are the motions for preservation of physical evidence. I would ask the court to grant that motion. just so that we can ensure that any physical evidence in the case has been preserved. I am willing to defer ruling on some of the others until the next court date. I would ask the court to grant the motion for access and preservation of the crime scene. I have not had a chance to discuss with law enforcement what their intentions are vis-a-vis the crime scene or when they would be done. But we would want to be able to visit the crime scene and conduct our investigation as soon as possible upon their completion there.
Okay? Let's take one at a time. Let's talk about first, and it's entitled D3, the motion for preservation of physical evidence. Have you seen that?
I have not, Your Honor, that has not been provided to us.
You want to take a quick look at that?
Yes, sir. On the crime scene, I can say it's something I've discussed with the police department already, and they are still working the crime scene. At the point that they feel that they have completed that, we anticipated the defense may be requesting access to it, and so that's something they can do. We are reaching out, though, to Planned Parenthood because it is their facility, and they may have some privacy issues around HIPAA and other things. So they may or may not want to be present during that also, or at least secure things that they may have some privilege concerns about, which should not affect a lot of what I would assume they're interested in the crime scene. So that's, arrangements are being made.
So
those are the two issues that I see.
So it sounds like you can make arrangements with the council they can go out and look at the crime scene once the police are finished?
That's correct.
The court is going to grant the motion for access to preservation of the crime scene. That's D5, and I will leave it up to counsel to make those arrangements with both the district attorney, and you can coordinate those issues.
Will do.
Okay.
The only motion we've been provided to date, Your Honor, is the indication. Actually, it's not a motion, it's just a notice of indication of rights.
Right.
So we have not seen the actual written opinion.
Judge, may I? Jeff Lindsay. We do object to the paragraph that says defendant with access on an ongoing basis to any and all items of evidence. We obviously would give them access, but we don't.
Paragraph is that?
I'm sorry, it's the first paragraph, Judge.
Okay.
We would give them access, but it would have to be through probably an investigator in our office or an investigator with the law enforcement agency.
Okay.
And then we do object to paragraph F, which includes email and text message correspondence by law enforcement and prosecution concerning the investigation of the case. We typically object to that, Judge, and we believe that is mostly work product. If there's information within any text or email that is Rule 16 material, we will provide that, but I don't think there's any other requirement that we would have to provide just all emails and all texts.
Okay.
If I may approach?
Yes.
Thank you, sir.
Any further comment from counsel from the Public Defender's Office?
No, Your Honor.
All right. The court is going to grant in part the motion for preservation of physical evidence. I am will grant paragraph A, paragraph B, paragraph C, paragraph D, paragraph E. The court finds that paragraph F can contain work product information. However, if there's Rule 16 information, the court obviously orders that that be provided. And I will grant also paragraph G. So it's A, B, C, D, E, part of F, and all of G. Anything else from counsel?
No, Your Honor. I'm assuming that if the court is going to entertain any further motion for expanded media coverage, that we would be able to discuss that before the media coverage started at the next hearing. Okay.
All right.
Thank you, sir.
Anything from the district attorney?
Nothing further at this time, Your Honor.
All right. Thank you. Court will be in
Thank you.
recess.
Please rise.